Thank you, everybody. And hopefully you understand the reasons for muting. Again, I'll repeat what Alex just told you, holding your questions until prompted. If you are online, you can always give your questions via online. Just type them in and our presenters will see them as well as the office. So number one, I want to welcome everybody and thank you. My understanding, we have about 200 people online for this call. We know it's an important subject. The State Hispanic Chamber is working hard to get out information, good information. More than that, especially trying to do sessions like this where we can at least have subject matter experts online to discuss these things. You can always go to our website, www.chcc.com, for both in English and Spanish resources that we have there. That's continually being updated. We'll probably go through another update tonight on it with additional information that we have. We encourage our chambers that are on the line, please feel free to use what we have with your members so that they have the most current information as well. Now, another thing, I know there's a lot of businesses out there that need help with how does this loan package go, other areas. On our website, on the right side, if you're looking at your screen on the right side, there's a thing that says SBDC. If you click on that and you put your information on that, our SBDC counselors and our SBDC affiliate center will get those inquiries and they will contact you for help. I know many of you have called us for assistance, and we're responding to those and trying to get our counselors to reconnect with you as well. But you can also go that, or you can just email the CHCC at info@chcc.com if you're requesting some services, and we will be glad to provide those services to our chambers and to our members. So with that, we feel that the most important thing right now is being able to make some immediate impact and relief. And so, how best can we help our chambers? Again, educational sessions like this that we'll continue to do with up-to-date information. And trust me, stuff changes on the hour. I mean, the presentation that the team probably had this morning when we went through practice has probably changed already, and I'm sure it has. But also, our chairman has charged us with also advocating, on behalf of small business, both at the state level and federal level, for some of that impact relief. And so, of course, we're in communications with the governor's office, the legislatures, and others in making sure that hopefully we get some of that as they're doing these stimulus packages. So with that, I'd like to turn it over to our chairman of the board of the California Hispanic Chambers of Commerce, Mr. Bob Gutierrez. Bob?
Thank you, Julian, and good afternoon, everyone. We appreciate you participating in this important session today. We're at a critical time right now where information is the key to working through all of this in our local communities. And this is a presentation that you'll receive for guidance on acting as such with employer guidance during COVID-19. Lisa Blanco Jimenez has put together a great presentation for you today from Neumiller and Beardslee. She is the shareholder and principal attorney there, and she's also the CHCC's general counsel. So please participate today with questions. Make sure you listen to all the key points that Lisa is going to be sharing with us and how to implement them into your own businesses. Again, we appreciate your participation today. Please stay safe, wash your hands, and continue to seek information that will help us all get through this situation. Thank you. Lisa?
Thanks, Bob. So we do have a presentation here for you today that I worked on with my colleague, Ricardo Aranda. And if you're there, Ricardo, maybe you can give a hello.
Hi, everyone.
I'm going to begin the presentation, and then I'll turn it over to my partner, Ricardo, to talk about the federal response in particular. But the point of this particular presentation is to provide you as employers with guidance during the COVID-19 epidemic. We are not your attorneys. And you'll find that through the course of this presentation, you might find quite a bit of reason to go out and get an attorney. But we want to provide you with the general information that you'll need to make decisions in your workplace. So starting with why we are here. On March 4th of this year, Governor Newsom proclaimed a state of emergency in California as a result of the threat of COVID-19. More recently, on March 19th, he issued a statewide stay-at-home order to slow the spread of COVID-19. The stay-at-home order is often referred to as a shelter-in-place order. And as you know, the Bay Area, before Governor Newsom's order, already had shelter-in-place orders in place. And of course, Sacramento County, San Joaquin County, and other counties in California have followed. So starting with what the stay-at-home order means, it means that everyone in California is required to stay at home. There are, of course, exceptions, the most critical being to get food and other necessities, to get necessary health care, to care for a relative or a friend, or to go to an essential job. Businesses that are needed to maintain continuity of operations of critical infrastructure sectors, and that's language from the order, are deemed essential. And thus, those particular businesses are exempt from the governor's stay-at-home order. This is a graphic showing the 16 critical sectors identified by the federal government and referred to in Governor Newsom's order. The most critical probably being healthcare and public health, but as you can see, there are quite a few other industries that are deemed critical, including media and communications, transportation systems, and of course, food and agriculture. After Governor Newsom's order, the California State Public Health Officer created a list of essential critical infrastructure workers to help state and local governments as well as industry partners protect our communities while still ensuring continuity of functions critical to public health and safety as well as our economic and national security. The list is available online. This is the link, and I'll pull it up for you because it's of particular assistance to us as we are going through this exercise. If you are wondering whether your industry is considered essential or whether particular workers in your business are considered essential, this particular document online, and again, up here is the website, can help you determine that. So you would go to your particular industry, this one first being the healthcare industry, and there's a description of people that are considered members of the essential workforce. Other industries are on here, food and agriculture. For example, it talks about workers supporting grocery stores, pharmacy stores, and other retail outlets that sell food and beverage products, etc. So this is a really good way for you to understand whether employees in your business may be considered essential workers. I would also use this document to assist in preparing essential worker notices or letters. You may be hearing that law enforcement has been approaching businesses and approaching individuals in their cars out on the road, asking them to go home unless they have a particular essential reason for being outside their home. And so what we've been doing for some employees is preparing notices that identify somebody as an essential worker. So for example, I have here just a quick one that I can use for myself. So it's on your employer letterhead. We called it a notice of essential critical infrastructure worker. And this language I've used, providing legal services as necessary to assist the firm's clients in complying with legally mandated activities, etc., is what I pulled directly out of that March 22nd list from the State Public Health Officer notice. So you could do similar things for your employees in order to give them something they can rely upon when they're out and about and commuting to and from work. So if you do have essential critical infrastructure workers, there are things that you should be doing in the workplace in order to keep those people safe and help prevent the spread of coronavirus. These are all from the CDC guidelines, which are available online. The website is here as well on the slide. The obvious ones, or the ones that are most known to people, are the social distancing requirements. People are expected to remain at least 6 feet apart. So in your workspaces, you should be maintaining the social distancing guidelines of at least 6 feet apart. So your workstations should be 6 feet apart. If you are going to have meetings in the office, people should be not within 6 feet of each other. And that includes also not being within 6 feet of customers or consumers that may be visiting your business. Additionally, the CDC has guidelines regarding proper hygienic practices, guidelines on how to wash hands, for example. You should also be disinfecting your workplace equipment, your furniture, your fixtures to help prevent the spread of the virus. In addition, you should be actively encouraging your sick employees to stay home. There are some guidelines along those lines as well that we're able to get online. Excuse me. Sorry about that. I'm having a little trouble because of all the other icons on. Here we go. So if you go to the interim guidelines from the CDC, this is actually a website that keeps all of the most present guidelines that the CDC is putting out. And they do have some really good resources for employers regarding actively encouraging sick employees to stay home. So you should actively encourage sick employees to stay home when they've shown symptoms. The symptoms of coronavirus are fever, cough, or shortness of breath, otherwise known as difficulty breathing. And there's also some instructions about how you should deal with employees who have sick family members at home. There also has been some relaxation of some of the requirements that we are aware of regarding disability discrimination. So for example, the guidance we're getting from the state and federal authorities is that it's okay to ask your sick employees what their symptoms are, because you're trying to decipher whether or not they have symptoms that are known to be associated with coronavirus or not. There was even some guideline that said that if you need to take someone's temperature in the office to determine whether or not they have a fever, that would be appropriate. But it is important to know that if you're going to keep any kind of medical records associated with these employees, that those should be kept private and confidential, and that you should keep them in a location away from their regular personnel files. And I'll turn it over to Richie to talk about our federal response to the coronavirus.
Ricardo, go ahead. You have to unmute yourself. Ricardo? Ricardo, can you unmute yourself, please? Lisa, while Ricardo's getting ready, I do have some questions for you. Would you be able to answer some right now?
Yes, I can do that.
Okay, sure. So we should have a couple here. Excuse me, folks, if I don't have the names for everybody right now. The chat was moving very quickly. So the first one we have, any updates on WARN requirements? WARN is WARN.
Yeah, I'll get to that in a later slide. So I'll definitely make sure to
Okay.
answer any particular questions when we get there.
Perfect. A few more questions. We also have, is the federal law, in addition to existing sick and family leave policies for businesses with 500 or more employees, or are businesses with 500 or more completely exempt from HR 6201?
So that's the next section. We'll be talking about the Families First Coronavirus Response Act, and so that will be addressed, as well as the questions about how you're expected to pay for the cost of these programs.
Okay. I also have, are the 80 hours of sick leave in addition to California's policy?
They are, and we'll talk about that in a later slide as well. So I can just continue with the presentation. I'm not sure what happened with Ricardo.
Yeah,
but
Ricardo's,
I'll go ahead.
we're going to get himself back on.
All right.
Hey, if you just want to, oh, are you back?
Oh, there he is.
Sorry about that. My computer picked the perfect time to freeze, so naturally. Hopefully everyone can hear me and can see me.
We're good, Ricardo. Go right ahead.
My screen. All right. So, all right. So that's the last one. Great. So I'm here to talk about the federal response, and which is known as the Families First Coronavirus Response Act, which was passed this past Friday. Seems like a while ago, but there was a lot of information to digest, and for a lot of information provided, there are still a lot of questions to be answered, and hopefully, a lot of times I can anticipate a lot of the questions, and the answer to those is we don't really know yet because there are still regulations being drafted and posters will be put out. But I will give you as much as I know about the Families First Coronavirus Response Act. So it provides a number of benefits. There are three that are focused on employment, and those are going to be one, the emergency expansion of the Family and Medical Leave Act. I'll be referring to as emergency FMLA. The second is federal paid sick leave and an emergency unemployment insurance and stabilization and access. We won't get into too much about that. Essentially, that just means that unemployment benefits will be extended if certain thresholds are met in California, which I believe they already have been. And I think that's will be discussed further along, but I'm going to focus on the emergency FMLA and the federal paid sick leave. And everything it was passed on Friday, but it's not effective until April 2nd. And then the benefits are set to expire at the end of the year. But first, the emergency FMLA provisions. Employees are eligible if they work for an employer with less than 500 employees. So the only employers that are exempted from this are the larger ones with 500 or more. And the employee has been employed for at least 30 calendar days. Now that's different from the current FMLA requirements. And so these eligibility requirements only apply to this emergency FMLA use. And it's also, so it's more expansive than what I'm calling regular FMLA, which normally has the 50 employee. It's only applicable if you have 50 or more employees and employees have worked for 12 months and have 1,200 hours. These will be more expansive to a lot more employees. So employees may take the emergency FMLA because of a qualifying need related to a public health emergency. And that means, it sounds broad, but it's actually pretty narrow. It means that the employee is unable to work or telework because of the need to care for the employee's child under 18
It looks like we might have lost Ricardo again. Lisa, if you want to take over for now.
Sure, I can do that. Let me just get my screen going. Ricardo, if you get back on, please let us know. All right, so continuing.
All right. Sorry, I'm back, but sorry, I don't know how stable my connection is.
Why don't I use the the PowerPoint I've got up here and you can continue with it. Go ahead.
Okay. All right, so before I left off, we were talking about what you can use emergency FMLA for, and it's the need to care for an employee's child under age 18 if the child's school or place of care has been closed or the child care provider unavailable due to a public health emergency. So it's only the FMLA leave is only available if the reason that an employee is unable to work is because of a school or child care closure. The benefits is that you get up to 12 weeks of job protected leave, and the first 10 days, or generally 2 work weeks, are unpaid. The employee can choose to use those first 10, supplement those 2 weeks with or 10 days with any vacation or sick time, or they can also use the federal sick leave, which we're going to get to later. The emergency use only, the employer must now provide paid leave for the rest of the 10-week period at the employee's regular rate of pay, which is capped at, I'm sorry, not regular rate, 2/3 the employee's regular rate of pay, which is capped at $200 and $10,000 per employee. And that's for full-time employees. For part-time, non-full-time employees, pays based on the average number of hours they work in the last 6 months, or if they've worked less than 6 months, a reasonable expectation of hours that they would have normally been scheduled to work. All right. And catching up on my slide here at home. Now these employers of less than 25 employees are exempted from the obligation reinstatement, provided they meet certain conditions, which, and again, hopefully these are clarified in these upcoming regulations. But generally it means that the position no longer exists because of an economic downturn, and the employer has to make reasonable efforts to return the employee for a year afterwards, after the leave. Right. And there are also exemptions that now the secretary and emergency responders from this leave benefit. And also the Secretary of Labor may also exclude businesses with fewer than 50 employees if the leave would jeopardize the viability of the business. Now that's also an undefined term which we are awaiting regulations on. I checked the Department of Labor website earlier today, and it just says that regulations are forthcoming. These regulations are probably going to be, I think they're expected by the time it goes into effect on April 2nd, but we just don't know when they're coming on. So in addition to the emergency FMLA, the Federal Coronavirus Act also provides federal paid sick leave. Now, employees are eligible if they work for an employer with less than 500 employees. This time there's no minimum length of employment required, just as long as they are employed as of the effective date of April 2nd. And the Secretary of Labor may also exclude healthcare providers and emergency responders. Other than that, if you're an eligible employee on full employee's regular rate or 2/3 of the rate, depending on the reason. And we'll go into there are 6 categories of reasons that federal sick leave can be used for, and we'll go into that in a later slide. Again, for part-time employees, the number of hours they get is based on the average hours worked in the last 6 months or a typical 2-week schedule. And in addition to the 6 categories, an employee may also use this federal paid sick leave benefit to fulfill the 10-day period for the emergency FMLA. All right, there are 6 categories of eligible use, and the first 3 are listed here. The employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19. Now, I'd argue that we're under one because of the state stay-at-home order. There is some room for a debate as to whether that actually means that employee is quarantined or isolated because they're sick. I'm, generally leaning on the opinion that we're under an isolation order related to COVID-19 right now. Another category is that the employee is advised by a healthcare provider to self-quarantine due to COVID-19 concerns. And 3, the employee is experiencing COVID-19 symptoms and seeking a medical diagnosis. Again, and for those three categories, the compensation is based on the full pay, not 2/3 pay. Now, the 2/3 pay comes into account when we're talking about reasons 4, 5, and 6, which are on the slide now. Again, this is for caring for an individual subject to a federal, state, or local quarantine or isolation.
Ricardo, you cut out there.
While we're waiting for him to come back on, I can address some of the questions I've seen pop up so far. So beginning with the question about, is there any kind of exemption or special treatment for nonprofits? So the answer is no. There's no distinction made in the law between for-profit and nonprofit companies. So long as you're an employer with less than 500 employees, these laws would apply to you. I also saw a question about, does it apply to part-time employees or newly hired employees? It does apply to part-time employees. The pay that you're paying, of course, will be adjusted for that part-time schedule in the 2 ways that Ricardo described in the earlier slides. As far as newly hired employees, the federal paid sick leave doesn't have any kind of minimum employment requirement. So you could be a day 1 employee or a day 30 employee, and the paid sick leave provisions would still apply. But the emergency FMLA does only apply to employees that have been working for you at least 30 days. Ricardo, are you back? Got another question here.
Back.
You back, Ricardo? All right.
Yeah, I'm back. Again, I apologize.
That's okay. We're getting through some questions. Go ahead.
All right. Okay, so we were talking, when I noticed I was getting cut off, we were on the other uses for paid sick leave, and these are the caring for individuals who are subject to a quarantine or isolation order or who had been advised to self-quarantine. The employee is caring for his or her child if the school or place of care is closed. Now, number 4, I make a distinction, it's not limited to family members, it's just the employees caring for anyone who's subject to a isolation order. And number 5 is if, again, similar to emergency FMLA, if the school or childcare facility is closed. And number 6 is I'll read it, and it says the employee is experiencing any other substantially similar condition specified by the Secretary of Health and Human Services. Really, that's just a catch-all provision so that if new conditions arise in the future, they will be applicable to this use. But I'm not aware of any any conditions that this would apply to yet. So I think it's more proactive going forward. And for the for these reasons, for reasons 4, 5, and 6 on this chart, the paid sick leave is based on the 2/3 rate of the employee regular rate. There we go. So yeah, so for reasons number 1 through 3, the rate is capped, regular rate of pay capped at $511 per day and no more than $5,100 per employee. And for reasons 4 through 6, 2/3 the regular rate of pay capped at $200 per day or $2,000 per employee. Now, other provisions of the federal paid sick leave law, similar to California law, discrimination, there's no discrimination or retaliation for using or asking to use paid sick leave. Employees are not required to find a replacement before taking sick leave. And it does not carry over, and it's set to expire at the end of the year, and it's not paid out at termination. Now, there's also a provision that the federal law does not diminish any right or benefit the employee is entitled to under any other law. Now in California, we already have paid sick leave, so that's creating some questions as to whether or not this is in addition to, or if it's in addition to what employers are already having to provide. My estimate is, my opinion right now is that effective April 2nd, employers should make sure that employees at least have the 80 hours of sick leave that the federal law provides. And so the number 1, or at least number 2 question I'm always getting is, how are these benefits going to be paid for? Now, and the short answer is that it's supposed to be in the form of tax credit. The IRS issued a press release at the link below, which basically says that the full amount of the leave can be credited to the amount that you would otherwise pay to the IRS in payroll taxes. And if that amount is not enough, then you can seek an expedited advance from the IRS. The claim form should be available, or supposed to be available sometime this week. And then again, there's the link to that list that has examples on there. I'm trying to see if I can access my notes right now. Oh, I can't click on it, sorry.
You want me to link on it?
Sure.
There we go.
Right, and if you can scroll down, there's, I think there's a section that says example that kind of, I guess, hopefully illustrates what I said there about how you can claim the reimbursement. So yeah, right there, if an employer paid $5,000 in sick leave and would have to deposit normally $8,000 in payroll taxes, the employer could use $5,000 of claim a credit of $5,000. If it has to require more, then they can get an expedited application for a refund. All right. So I see there's a lot of questions about this, and I don't know if I can get to some of them right now. A lot of questions on the number of employee requirement. It's if you're an employer that has less than 500. So I see, does it apply to less than 50, less than 10? Yes. It's less than 500. Am I still there?
Yep, we hear you.
Had to notice that I was getting unstable. And someone asked if it applies to employers with more than 500.
Oh,
You
I think
cut
now
out
we
there.
lost him.
So it does not apply to employers with 500 or more employees. And when I was reviewing the legislative notes on why that is, the idea was really based on an assumption that those larger employers already have adequate sick leave policies and vacation policies in place. Now, many could argue that that's not necessarily the case, and perhaps it's a result of particular lobbying efforts, but as of now, it only applies to employers that have less than 500 employees. To answer another question, the employee count does not take into consideration a 1099 independent contractors. Now, if you have a workforce consisting of exclusively or close to exclusively 1099 independent contractors, it's possible that if those people were misclassified as independent contractors and that they should have been treated as employees, that a claim could be made against you as the employer, that those people are entitled to these leaves because they should have been treated as employees and were in fact misclassified. So the shorter answer is no, it doesn't apply to your 1099 workers. But if you are misclassifying those workers and they should be treated as employees, you could face claims for not providing these leaves. Ricardo, are you back? Okay, the final slide on Ricardo's portion regarding the federal response is the posting or notice requirement. That was one of the questions that we received in the chat as well. So there is a requirement that you post a notice in a conspicuous place on your premises. This is the same language we use for the notice requirements that are otherwise required of employers. Now, the ironic thing is that if you've got closed businesses or reduced workforce, and people are working remotely, posting it on site isn't going to help get the word out. So what we're recommending is that you, in fact, distribute to all employees that are either on leave or teleworking so that they're aware of the Act's requirements, which may be by email or mail, getting that word out. So there is a model notice that the Department of Labor is required to create, and that is going to be on the Department of Labor's website no later than tomorrow. So once you have that notice handy, you can put it on, print it out or print it or put it on your company letterhead and get it out there to your workforce. Ideally in advance of the April 2nd effective date. So I'm going to move on and talk about, reduced hours and layoffs. I want to start by talking about temporary or permanent layoffs. If you cannot identify for your workforce how long the layoff is going to last, then you have to treat it like a true termination, and your termination obligations are in fact triggered by the layoff. At the beginning of this pandemic, employers were using like April 6th was a really good date. A lot of employers were using because that was what the schools were telling us, and that was what some of the other notices had said, and so they were telling people to come back on April 6th. And so they weren't truly laying people off. They were just putting them on an unpaid absence status. Now that we are really unclear, and it's becoming more apparent day after day that this thing is going to last longer than what we may have originally thought, employers are having difficulty telling people when they can come back. So if you can't identify for your workforce when they'll be able to come back, then you should treat it like a termination and give them their final paycheck, including all vacation hours, give them their unemployment notice, their COBRA notices, etc. So that's something to be aware of. Additionally, depending on the extent and size of your closure, you may have to follow the federal and California WARN Act requirements. However, with regards to the state WARN Act, the timing and penalty provisions are suspended when you have a layoff that's related to COVID-19. You still have to give your employees reasonable notice of the layoff, but you aren't going to be penalized for that being inadequate notice in the way that you would have been otherwise, or with regards to a layoff not related to COVID-19. There are a number of state benefits available to your employees that may not be working because of a reduction in force or a closure. The EDD has a really good website on right now regarding coronavirus benefits in particular. So they talk about unemployment insurance, paid family leave, and disability, which is SDI. I'll open that website for you now. It's actually a really good resource to send to your employees that are not able to work, because it explains what they may be entitled to depending on the reason they're not working. So for example, if they're sick or quarantined, they could apply for SDI insurance benefits. Thanks to the governor's order, there is no longer a 1-week waiting period on SDI benefits. If they have to be caregivers for somebody who is ill or quarantined as a result of COVID-19, they can file a paid family leave claim. If there's a school closure, they can file for unemployment. If they've had a reduction in hours, so they're still working, but you've had to reduce their hours because business is slow, they could file for what's called partial unemployment insurance benefits. I will warn you though that if they're high wage earners, they likely wouldn't qualify for any kind of partial unemployment insurance so long as they're still making $450 or more a week. So there's some really good information on EDD's website and links out to the actual claims web pages so that your employees can take advantage of those state benefits. It's important that if you are making layoff decisions, your decisions are not made in a discriminatory fashion. So you can't just lay off people because they're from a particular country or because of their age. Again, 65 and over has been the CDC's risk category age-wise, but you can't just make decisions based on age, national origin, race, or any protected characteristic when making your layoff decisions. Moving on to reduced hours. So how do you pay people when they're not working what they had normally been working? So if you've got staff who are non-exempt hourly employees, you only have to pay them for the time they're actually working, whether it be on-site or remotely. You're only paying them for hours worked. You do have to be careful though, that there may be situations where you may be responsible for reporting time pay or on-call pay. So reporting time pay, that situation may arise when you decide suddenly to close your doors or send people home because of a lack of work after they've already reported for the day. And reporting can mean showing up to the physical workplace, or it can mean clocking in or checking in remotely. If they've already done that and then you tell them there's no work for you today, you may be responsible for reporting time pay. It is important to note that there are exceptions to that requirement, including where a government agency has told you you can't work or operate business that day, and certain other acts of gods and emergency situations. So if you're not sure whether that applies to you, you might want to do a little more research or present your particular facts to an attorney to walk you through. On-call pay, that's where you have someone on standby or on-call status. Whether or not those workers are entitled to pay depends on how restrictive their on-call status is. So the more restrictions you place on someone who's on call, the more likely it is that you would have to be responsible for paying them their time while on call. So for example, if you say they can't leave home, or you say they have to have their phone on 24 hours a day, if you say they can't consume alcohol, the more restrictive you are about what they can and can't do during the on-call time, the more likely you'd have to pay. So that might be something you might want to seek counsel on as well. If you have exempt salaried employees who are working less hours, they are still going to get their full weekly salary. So whether they're working 40 hours a week, 60 hours a week, or 20 hours a week, if they're true exempt salaried employees, their pay is fixed and it's not going to change just because they're working less now. If they are taking full day absences for personal reasons other than sickness or accident, you can deduct from their pay for the equivalent of a full day's salary, so long as there was work available for them, but they chose not to work. And that's not really the situation we're talking about here when their hours are reduced because of your business changes or needs. It's important to note that you have their PTO or vacation time banks reduced for partial days worked. So if they're working only 4 hours a day, you can take 4 hours out of their PTO vacation time, for example, but you can never reduce their pay for partial day absences. Additionally, if you are thinking about reducing their base salary, you want to be careful that you don't reduce it so low that you've now jeopardized their exempt status. So the minimum salary that can be paid to maintain an exempt status is 2 times the minimum wage for full-time employment. Okay, so if they're not getting 2 times minimum wage, then they will lose their exempt status. But so long as you're staying above that minimum, you could, in theory, reduce their salary. They used to get $70,000 a year. Because business is slow and they're not working as much, you could reduce them to 60,000 or some other number, so long as it's more than twice minimum wage. A final slide about remote work. So a lot of people are having their employees work remotely, and that's the recommendation where they can do their work remotely, that you actually make accommodation for that to happen. And if you're a non-essential business, then the only way you could be operating would be remotely. So some words of advice with regards to your remote workforce or teleworking. The first thing is you're going to want to do things in a way that you are avoiding wage and hour claims later. This means you're going to want to continue with your timekeeping obligations. Your employees should be submitting regular timesheets in the way that they were previously, so that if they are working overtime, which is more than 8 hours in a day or 40 hours in a week, that they're being paid accordingly. Additionally, you're not there to ensure or encourage the taking of their rest breaks and lunch periods that they're required by law to have. So what I would strongly suggest is that you send a reminder to your employees that they are obligated to take their breaks and their meal periods according to your policy, despite that they're working from home. Additionally, you want to be careful that you're reimbursing them properly for business-related expenses. So this is going to come up quite a bit. Unless you're providing them with the resources to work at home, you're going to come to a point where you have to account for and pay for their business use of personal equipment, their business use of their cell phones, their business use of their internet service at home, their Wi-Fi. You're going to have to account for that in some way. And I can tell you that with all the scrambling we've been doing to set up people remotely, we've kind of pushed that issue to the side for now. And that's okay. We've got other things that we're really worried about these days. But at some point, and I would say not too long from now, in the next few weeks, you should figure out what you may owe your employees for them having to use personal items for your business work. The other concern about people working at home is that you have this increased and unusual exposure to workers' comp claims. So you're not in a position to make sure that the employee's home is a safe workplace. And many things can happen in a home office as far as creating injury while on the job. People can trip over power cords, trip and falls, things falling on people because their workplace really isn't set up to be a workplace. at home, a lot of things can happen. So the immediate advice I have in that regard is to have very explicit rules and policies in place explaining to employees how they should keep their workplace safe and to ensure that it is safe. So you can only go so far in this regard because it's not your workplace, but there should be some efforts to ensure that people are doing the things they need to do to maintain a safe workplace at home. The last thing is just implementing some kind of supervision methods that you would otherwise not be worried about if people were in your environment. So even for exempt salaried employees, I've been encouraging people to require some kind of timekeeping or assignment log so that people can be accountable for what they're doing on your dime. So having people report daily or weekly about the tasks they've completed and when they've completed those tasks is going to be important. Additionally, it's important that you think about being more flexible about what the workday looks like. So for example, you may have people normally work in your workplace from 8:30 to 5, but if they're home and they're having to assist their children with their online distance learning and other things that may come up during the day that would distract them from work, you may think about making some kind of changes to their work hours to accommodate the other things that are taking their attention while they're working from home. So having those conversations with employees, being flexible while still holding them accountable, those are the types of hurdles that we're encountering as we move into a more remote workforce. So that's what we have as far as our presentation. Maybe we can pick up with some of these questions now. I know we have quite a few.
Yeah, there's a few in the chat there, Lisa, if you want to take a look.
I can kind of scroll through. So one of the big ones we're getting is, are we going to get these slides? The answer is yes. What I will do is I will create a PDF of the slideshow itself and get it to the California Hispanic Chambers to circulate to everyone that has signed up for the Zoom meeting today. They have your email, so I expect that that will be sent to you guys via email. Is that right, Alex?
Yes, everybody who signed up, as long as you signed up through our Eventbrite, you should be able to get it. If for whatever reason you don't get it within the time frame, just let us know. We'll get it over to you guys. Yeah, we should be fine with that. Any other questions, Lisa?
Yeah, additionally, I wanted to let everyone know that we, my partner Ricardo and I have been working on a document that is kind of an FAQ or cheat sheet for how to deal with some of these issues that we've talked about. We had one that was from last week, and last week to this week is a totally different world for us given everything that's happened. So we will be updating that in the same email list that's used to send the PowerPoint. We can also circulate that information. It'll probably be another week for that to come out, but that's just because we need to update it with all the new information we have now and that we expect to have at the end of this week. So we'll continue to keep you informed as much as we can about this sort of ever-changing state of the law, and if it's appropriate to do another presentation through the chambers, we will do that as well.
Lisa, really quick, we have some folks asking if the audio version will be available. I know, like you were just saying, it does change week to week. So if you want to speak to that, if you think that would be poignant, or if you think that for right now, just because of how quickly everything's changing.
I think for this week, at least, we should make a recording of the presentation available for people to watch again. That's fine with me.
Okay.
One of the things somebody was asking about is a telework policy. So that's actually something that we are advising and creating for our clients, is a written policy that will deal with workers' comp issues, can deal with accountability issues, and can deal with reinforcing other policies like break times and meal periods. And I especially like it because we will put language in it that requires the employee to do certain things to keep the workplace safe. And so they're on notice of their obligations in that regard. So if you don't already have a telecommuting policy or telecommuting agreement with your remote workers, you should definitely look into putting one in place. Okay, I think that's where we'll end today.
Hey, Lisa, thank you so much. I'd like to thank everybody for jumping on with us today. Like I said, we will work to get the information from Lisa and post out to everybody who registered. We'll also work to get out the recording out to the folks too. We're just gonna clean that up. Once again, thank you all so much. Be on the lookout from stuff from us. This is changing daily, as Lisa said, and we appreciate you all being on here. We hope you all have a safe and wonderful day. Thank you.
Thank you, Alex. Thank you, Lisa.
Thank you.
Thank you, everybody.